Speak Up. I am Sandra Schulte. Welcome back to the show. Today I'm happy to have Peter A. Mahler with us. Thank you for coming, Peter. It's
Thanks
a pleasure.
for inviting me.
Peter A. Mahler is a senior partner at Farrell Fritz, PC, where he concentrates his litigation practice of business divorce cases involving dissolution and other disputes among co-owners of closely held business entities, including limited liability companies, corporations, and partnerships. Peter publishes the widely followed New York Business Divorce blog, which features over 900 articles. Peter also authors the practice commentaries for limited liability company law and the revised Limited Partnership Act for McKinney's Collisated Laws of New York Annotated. McKinney's Collisated Laws of New York books are like the Bibles for attorneys. Today, Peter Mahler is going to talk about divorce, not marital divorce. Instead, he will talk about business divorce. How did you become interested in practicing as a business divorce attorney?
Sandra, after I finished a federal court clerkship, I went into private practice where I was very fortunate to work with some senior partners who had cases involving disputes between business co-owners. And there were a number of these cases over the following years. And I really went to school in that type of case. I mean, I really had to self-educate, learn the law, learn the procedure. Some of these cases go on for years. They raise all sorts of different issues, and there wasn't really much out there written about the subject, and I can tell you about that a little bit more. But I really went to school and had to teach myself, and I developed over some number of years a real expertise in those types of cases. And then, as I got older and I wanted to get my name out there, I started writing about business divorce topics in legal publications, and then we get into the 2000s and everyone is now looking for information on Google. People are starting to blog. I started to blog in 2007, and by then I was already getting some following and business, people calling me, having read my articles, and then when I started blogging, it sort of snowballed over the years to the point whereas before I was doing a mix of different things, by the time we get to the mid-aughts, I was pretty much only doing business divorce law. And that's a very rare event, I think. There aren't many lawyers like myself who will only do business divorce law, but I feel very lucky, I call myself a one-trick pony, but it's quite a pony because there's just so much, especially in New York. If you're going to be a business divorce lawyer, New York is the place to do it, just because of the volume, the number of businesses, the number of family-owned businesses. There's a lot of action in the business divorce arena in New York.
Just for curiosity's sake, what percentage would you say of business divorce involves families?
Interesting question, and my answer is that for many years it occupied a minority portion of my business divorce practice. And then I can't put a date on it, but over the last 10 years, I would say more and more and more of the matters I handle involve family-owned businesses. I don't know, I have my own theories as to why that is. I think it may have to do with the fact that we're dealing with baby boomers now who are in their 60s and 70s. They inherited maybe a real estate portfolio from their parents, and now the siblings aren't getting along and things erupt. But it is a fact that most of my work now is with family-owned businesses.
Would you say it has to do with members of families who are older or members of families who inherit a business who are younger but want to go in different directions?
I would say generally older, that's not always the rule, but I think that generally is here. I mean, a lot of it in New York is a real estate town, and there are a lot of families who owners of portfolios, family owners who inherited their portfolio from a father, a mother, a grandfather, their forebears who may have bought up properties in the 20s, 30s, 40s. I remember one case I handled where we were now probably into the fourth or fifth generation, who were already in their 60s and 70s. The number had expanded over the years of co-owners, so maybe I'm making up a number because I don't remember exactly. Maybe there's a dozen, people now sharing a partnership interest in this portfolio. And they've been suing each other for 20, this is a real case. There was not one of them who had not either sued another or been sued by another. It was insane. I mean, even the two clients I represented in that case at one point earlier, they had sued each other. And that's because they had a really lousy partnership agreement and there was no thought of succession planning or anything that went into it. But going back to your question, a lot of it, I would say, is with the older generation, not so much the young, and particularly in the family, but also even non-family. I mean, you have business partners who maybe started a business when they were in their 20s or 30s, early 40s, got along great for 20 years, and now they're starting to have, their interests are starting to divert. This one wants to stay in business, this one wants to retire to Florida, so those kinds of things happen.
What does a business divorce attorney do?
Well, generally, look, there are all types of disputes between business co-owners. There's the ranging from the mildest one would be someone who feels that they're not getting access to information about the business, so they'll bring what they call a books and records proceeding, which is a special type of lawsuit that the statutes allow, minority non-control owners to bring for books and records. Even that can ignite a firestorm, don't get me wrong. Stepping up, you would go maybe a lawsuit claiming breach of fiduciary duty, that you, again, I'm a minority owner, you're the majority owner, I think you're embezzling, I think you're using company funds to go on vacation or whatever, or I think you're just making other decisions in your self-interest that are not in my interest. And that's, those kinds of suits are, I hate to say it, a dime a dozen. And then there's sort of the nuclear bomb, which is dissolution, all right? So what I would do as a lawyer, and I could be on either side. I could be bringing these actions, I could be defending against these actions, but those are, generally speaking, the main types of cases that a business divorce lawyer would handle. And the one thing I'll add, though, is that in a lot of these cases, either by statute, usually by statute, it results in a buyout, one side of the other, under the terms of let's say the dissolution law has provisions that allow the one who's being sued to elect to buy out the other one at fair value, it's called. And that results in an appraisal proceeding. And a lot of my work these days is appraisal proceedings where I get to work with real estate appraisers, business appraisers, and the trial really is the battle of the experts arguing over how much, the interest is worth. So it's a varied practice, different types of cases. I love the appraisal cases. I do a lot of those because I like working with these experts. I find them to be very talented and smart people, and it's an entirely different discipline than what I do as a lawyer. So I get to learn about a different, discipline entirely. But there, there's great variety in the types of matters we handle. And then it's not always litigation. A lot of the things that come to me, no one has sued anyone yet, but there is trouble on the near horizon, and they come to me or...
They're getting a battle plan in place.
Well, it's smart to do that
Nice.
before everyone really goes to war. And so a lot of the engagements I have are not litigation engagements, is people looking for solutions to see if we can avoid litigation. And I love, really that's my goal when those folks come to me. What can I do so we don't end up in court? Court is not a fun place to be, and I can talk about that if you'd like.
You're welcome to. What are some of the typical scenarios
Well,
that lead to disputes?
Yeah, usually the one that I'd say is most typical for my practice involves well, there are two most typical ones. One is where you have a minority and a majority, and the minority is accusing the majority of some form of freezing them out, whether it is terminating their employment with the company, and sometimes your employment income is really the only thing you're getting out of the company, right? Or other insults, financial or otherwise, being not getting information, not trusting the management decisions that the majority is making, all sorts of things like that. And then the statute, the New York statute, allows that minority shareholder, if they have at least 20% ownership of a corporation, I'm talking about right now, not LLCs, to bring a dissolution proceeding, which is asking the judge to dissolve the company on the grounds that I'm being oppressed. Right? That is a very typical scenario. And another typical scenario is where you have a 50-50 owned corporation or even an LLC, where you go into court for dissolution, saying to the court that you should dissolve the company because of some form of deadlock. We can't agree on major decisions, and because of that disagreement on major decisions, the company is in jeopardy of failure, of no longer being financially viable, or maybe it's already on the way, down. So those are very typical scenarios for dissolution type cases.
And also too, one party says, hey, this proposes to risk. Even though the risk is small or whatever, they use the word risk as a tool.
Yeah, I think that falls into the broader category, and again, it would almost always in that situation being the non-control owner going against the control owner, accusing the control owner of making some sort of bad decision for the company. Even in your example, you're not really talking about self-dealing. You're just talking about someone making a terrific mistake that's hurting the company.
It could happen. It is a possibility that this, whatever it is, will lead to disastrous risk. Not that it is doing it, but it is a possibility.
Well, yeah, and that would, if something is in progress, that would call for not necessarily bringing a lawsuit until it happens, or until you actually know it's about to happen. Because if it's just a possibility, a judge is going to say, "Well, it hasn't even happened yet. Why are you in front of me?" But that does happen, and you try and it's nice when you have lawyers who understand this, talking to each other and trying to see, is this relationship a viable relationship? Sometimes a relationship is it's dead, right? It can't be repaired, and now the focus has to be on, is there a way that we can separate them? Doesn't necessarily mean destroying the company, but is there a way that we can fix this so that they don't have to, basically, stay in the same bed together?
You were talking about the courthouse. You started talking about the courthouse.
Yeah. It is New York Supreme Court, particularly in downstate, New York County, Brooklyn, the more populated areas of New York State. The caseloads of the judges are just, through the roof. And so it's not like you can expect to have, the undivided attention of a judge for the next month or two or three. It's just not the case. And lawyers who tell their clients, "Oh, we'll bring a dissolution case and we'll have it done and finished in 3 months," forget it. It just doesn't happen. In other areas of the state, you'll probably move things quicker, but downstate, we don't have enough judges to handle the caseloads, and as a result of that, you can't get the attention that you'd like as quickly as you'd like. You may be waiting for decisions for months, many months sometimes. It varies judge to judge. New York procedure allows, there are all sorts of ways that lawyers can stretch out a case through discovery demands and fights over discovery and taking an appeal, and there are all sorts of, I won't go into the details, but I've had cases that have gone on, I think my record is 8 years.
Wow.
That's a long time. Now, that's not typical, but it's not unusual to be in court in these types of cases, unless there's a quick settlement, 3, 4, 5 years. And that's expensive. It's the expense, and it's the distraction, and you're living now under the same roof with your so to speak, with your co-owner, for a year or 2 or 3 or 4 while you're suing each other in court. It's not a good situation.
Yes, it ruins your life.
It can, yeah. I mean, I often call myself, what do you do? I say I'm a professional handholder, because the clients are in extremis. They're, the anxiety, the level of anxiety, the level of uncertainty. It's sort of like why we call it business divorce, intentionally to make you think of a marital divorce, because people think of marital divorce, as hell on wheels. And instead of fighting over children, we're fighting over the company, but it can be just as intense.
The company is the child.
And in the family, it's a whole nother layer. I mean, we joke, it's not so much of a joke, we lawyers talk about crib fights. Daddy loved you more than me. That's not what's being litigated, but that is sort of, what's going on. They're playing out, in part, resentments against siblings or uncles or aunts or nieces or that have been, around for decades or longer. So there's a lot of hand-holding.
Is there a tendency for some judges now, because of the intensity of the huge amount of caseloads, not to really know the case?
Well,
and make quicker decisions as a result.
Yeah, there is good news even in New York, and particularly in Manhattan. For 20 or 30 years now, the courts have something called the commercial division, and in New York County we have, I think the count is 8 or 9 commercial division judges. Their caseload consists entirely of business disputes. And so, when we bring one of these cases, and they can be very complex, I'm dealing with a judge who knows business law. And that's what they're specializing in. And so that's been very helpful. And those judges, I'm not trying to insult the other judges who have, a terrific caseload as well, and they do their job well. But these are we have the benefit of the commercial division that exists not only in Manhattan, but in Kings County, in Queens County, Nassau County, Suffolk County, all the downstate counties, except Staten Island, I think. Westchester has it, and it's been a tremendous benefit. It's not perfect. These cases can still go on for a long time. Even those judges have a large caseload, but it's much, much better because we have judges who understand what we're talking about. If I have an appraisal case, which can be a very complex area, and I go in front of a judge who's never done an appraisal, it's like, do I really want this judge to decide an appraisal case who's doesn't know anything about appraisal? No, the commercial division judges do, though, because they have these cases and they learn just as the lawyers learn. So it's not all bad news.
That's
but
right.
it's still expensive and distracting, and it can take a long time.
Do these situations always lead to the courthouse?
No. I mean, I get a lot of calls and engagements where, as I think I indicated before, no one has sued yet, and we're trying to, both sides are trying to get to a deal to resolve their dispute. I handle a lot of that. I can't put a percentage on it, but that is absolutely the case, and our job is to try and keep our clients out of court. That's the happiest outcome.
And I guess the most difficult outcome is when one side would like to find a way to come to a non-court resolution, but the other one doesn't.
Yeah, and that happens a lot, particularly, again, in the situation where you have a control person and a non-control person. And the control person has the leverage, has the advantage, so, but even then, it's not entirely the case that they're never going to also want to, resolve the situation without having to go to court. I mean, I don't know that anyone there may be some exceptions, but I really don't know anyone who says, gee, I'd love going to court. I love spending money on lawyers,
Do business divorce cases involving family-owned business present unique challenges?
Yeah, I started to talk about that, and it really is the case. And yes, they are unique challenges because of the emotion even non-family, we have a business, they're not relatives, but maybe they were friends when they started in business, whatever. But when you're talking about, father against son, uncle against nephew, sibling against sibling, which is the most common thing, the emotion is intense, and it makes it more of a challenge for the lawyer, because as a lawyer, I want the client to make business decisions, right? Business decisions and emotions don't always line up together, and so it can be a challenge for the lawyer to get the client to really make the business decisions and put the emotion to the side. I've seen situations where you have a fight between parent and son or daughter who has a grandchild, and they're holding the grandchild hostage in a sense. They're not going to let their parent, the grandpa, the grandmother, even see their grandchildren because they're fighting over the business. That's pretty ugly.
Yeah,
but it happens.
They can't stand to see that other person walk through the door to take the grandchild or whatever.
Well, I called it hostage taking.
Yes.
It really is.
Yes.
Do give me what I want or else.
Yes. Do the remedies differ depending on whether the company is a partnership, or is a corporation, or is a limited liability company?
Absolutely, absolutely. When I started practicing, we didn't have, I'm going to call them LLCs, limited liability company. They didn't even exist in New York or hardly anywhere else. And it was all about corporations, usually S corporations, and once in a while partnerships too. And there are statutes in place that, for instance, the minority shareholder oppression lawsuit that I talked about, there's a statute that allows you to do that as long as you hold 20% of the shares. Then along came LLCs. And with the corporations, there was that buyout election, which is a good thing, right? It gets rid of the dissolution, and someone is going to buy out the other. Maybe they're going to fight over the price. LLCs came along in New York in '94. Different statute, completely different statute, different remedies, different standards for dissolution, no buyout election like there is under the corporation law. So the rules are different and the remedies are different. There are some in common as well. Both of them have, you can sue to get access to books and records. Both of them you can sue for breach of fiduciary duty. Those types of, garden variety claims can be the same. But when it comes to dissolution, the standards are different, the statutes are different, the remedies are different. And that's something that many business people don't appreciate when they form their LLC or their corporation. And that's where I always will preach that you really need to, bring in a lawyer at the beginning when you're starting your company, and not, it's good insurance, really.
If someone wants to get a hold of you, how can they do that? Would you tell us that slowly so people can write it down?
Well, I am very reachable by telephone, by email. It's all on my blog. It's on my firm. I have my bio on my firm's website, farrellfritz.com.
Farrell, say it again slowly, please.
farrellfritz.com is my firm's website, and my bio is there, and my contact information is there, and also on my blog, which is how most people come to me.
And you are? Your name, sir.
Oh, I am Peter Mahler. I thought we already established that.
We did.
And my email is pmahler@farrellfritz.com.
What would you like our audience to take away with them?
I think the most important message, certainly to people who are just now forming a new business with partners, and I'm using the word partner loosely, the importance of finding a lawyer, or two lawyers, if that's fine too, to put together a really good, whether it's a shareholders agreement for a corporation, or an operating agreement for an LLC, or a partnership agreement for a partner. That's the best insurance against having to use a lawyer like me in 5, 10, 15 years to put together a custom agreement that anticipates as best as possible, not just the good things that can happen, but the bad things can happen.
Especially the bad things.
And mediation is a very popular thing now to put, and popular is the wrong word.
Why is mediation very popular?
Well, it is an alternative to going to court. It allows parties with you hope to get a very good mediator, which enables the parties to come to their own agreement. The mediator can facilitate the parties coming to their own agreement, and it's always, always better to be able to make your own agreement, sort of be the master of your own fate in a sense, rather than putting it into the hands of a judge you don't know what they're going to do. Judges are not, are not gods. They get it wrong sometimes. Then you have to appeal. Even appellate courts get it wrong sometimes. So mediation is, I would always recommend that in your agreement. Require mediation in your agreement.
Not arbitration?
Well, if the typical agreement, if it says start with mediation, if the mediation doesn't succeed, then you can mandate arbitration. I will say I'm not as big a fan of arbitration as I used to be because it's coming more and more like litigation, takes longer, more expensive, they're allowing more discovery, things like that. But you can even design your own arbitration to dictate, the process and how much discovery there would be. Are we going to allow depositions? You can customize that, and so that's the biggest takeaway. Half the pieces I write on my blog end with saying the same thing: get thee to a lawyer, and do it early.
And don't do a customized deal rather than something you get on the internet.
Right. One of those off the shelf, you pay a few bucks and you get a form that has some blanks and you just fill in the name of the company and that date. And no, that isn't a recipe for trouble. I've seen that happen. Anyway, I know there's a lot more I could talk about, and it would be great to come back. And
I would love it if you would come back.
All right.
Okay. I really want to thank you so very much.
I had fun talking with you.
This is Speak Up. I am Sandra Schulte. Have a wonderful, wonderful rest of the day. Goodbye.